So in this section, I wanted to spend just a little time talking about the court's important timeframes. And just understand that there is a history behind this as to why there's court frames when you file something in district court. And as soon as you file it in district court, what you're going to find is that the court is going to put you under certain guidelines. But it's also why we actually try to get the divorce completed and ready to go before we actually file it in district court so that we can avoid some of these court frames. But what happened is historically, and this goes back 30 years, is this, and it also has to do with judges. And so I hope I'm not going too far in the weeds, but sometimes having you understand the reasoning behind the courts doing something is helpful. And what happened is that the Minnesota Supreme Court decides how many judges go in each judicial district and in each county. And so they were doing it based on the amount of cases in a caseload that each county had. But what was happening is these divorces, people were starting their divorces and they were just languishing there in the court system as open files. And so the Supreme Court got savvy and they said, wait a minute, you've got all these open cases. Why haven't you seen that they've gotten closed? And so they said, we're not going to give you, any more judges until you start, you have to start keeping better track of what's going on in these cases. And we want them done within the year, if at all possible. So that's why you're seeing this pressure to, once it's filed in district court, what they're going to do is they're going to move it along. So the first thing they're going to do is they're going to go and they're going to send you out a letter saying, okay, your case has been assigned. And this is in most county courts. There's a couple of counties where a case isn't actually assigned to a judge, but in most cases it's assigned to a judge and it is given a case file number. And then you're given notice of that. Now, just understand that once you get that notice, you only have 10 days to remove that judge. And basically, it's like you get one free out. And so if you really don't like the judge, you can say, I don't like that judge, but then they're going to give you the next judge. And so in most cases, it doesn't make sense to remove a judge, but I just want you to know you have that 10-day time frame. And then they're going to set it on for what we call an ICMC. And that stands for Initial Case Management Conference. And this is supposed to be an informal hearing, but most of the time, especially for self-represented folks, if both sides are self-represented, the courts will the judge will still take the bench and will, may or may not be in their robes. But what they want to do, the whole purpose of it is they want to know, what are the issues? Are there any agreements that the parties have? And if the parties are willing to agree to move into what's called mediation or some other form of alternative dispute resolution. And that's the purpose of the Initial Case Management Conference. What you need to know is if you do file this in district court, for that Initial Case Management Conference, at least 3 days, 2 or 3 days ahead of time, you're going to need to be filling out, it's called an ICMC data sheet for the court. And some of the courts require that it be mailed to them, and in most cases emailed. And all of that is on that initial sheet you receive from the court. So here is my next big hint for you. Everything you get from the court, make sure you read it and make sure the court has your correct address and email, because, and then pay attention, because the last thing you want to do is miss a court deadline, because it can seriously affect your rights in your divorce. But so let's say you have the ICMC and the parties have agreed to some form of ADR. ADR, Alternative Dispute Resolution. And that's a term of art. It just simply means some form of mediating your agreement or arbitrating your agreement. There's a number of different ways we can do that, and that could be a whole section in itself. But most of you probably don't need it other than mediation. So I just want you to know that it is in the statute that you are required to attempt good faith of alternative dispute resolution of your case prior to going to trial. Now, I hear it all the time. Wait, do we have to go? And the answer is, no, you don't. if you have an agreement to everything, obviously there's nothing to mediate. But if you don't have an agreement to everything, the courts require that you attempt it. Now, the only point to make about the mediation is that you can get out of mediation if there is serious allegations of domestic abuse or actual domestic abuse. But even then, I want to tell you that mediation is still a great way to settle your divorce issues. And so you just simply say there's been domestic violence and that you want to be kept in separate rooms. And every mediator I know is willing to accommodate that so that you can try and reach the agreements. But I do want you to know there is a carve out in the statute. So that's the ADR requirement. So E&Es, I've mentioned the term E&E, early neutral evaluation. Now that's simply a hybrid of mediation. And instead of two parties going and meeting with this neutral third party, and the mediator goes, oh, what would you like? And, oh, did you hear what that person said? Okay, what would you like? Okay, and then tries to get an agreement. Early neutral evaluation is done with experienced family law attorneys or financial accountants, if it's financial. And what you each do then is you each give your side of the story, so to speak, on how you want custody and parenting time to look, if it's an SE&E or if it's an FE&E, financial early neutral evaluation. The other is social. And that has to do with the money. And after each of you speak, they'll go and they'll put the things on a spreadsheet, and then they give you their expert opinion. And it is just their opinion, but understand these are folks who have worked with the courts, and their opinion means something. And sometimes I call it, the neutral voice of reason, because they don't have a stake in the outcome, and so they can give you a really good idea on if your proposal is reasonable and ways that you can settle. And that's the purpose of it. So then it's important that the courts are going to give you a couple months to try and use the mediation or ADR system. But then if you can't settle it, and they may request, there may be a review hearing that's scheduled just to see how things are going. But if they don't hear from the parties, or if the parties can't reach agreements, then the courts will set it on for a pretrial. Now understand that the courts call these pretrial settlement conferences. And again, their sole job is to try and get you guys to reach agreements, because the last thing the court wants to do is to hear your case. And I hear people, I don't hear it so much anymore, but I used to hear people saying they just want their day in court. And, they think that justices somehow are not human beings with all the prejudices we all have. And I got to tell you, they are human beings, and they do have prejudices. And even though they say they can be impartial, don't count on it. I knew a judge down in Mankato, and he had 5 daughters, and he was a good Catholic man. And you better believe he had prejudices in favor of mothers. And he never said it from the bench, but I guarantee you it was reflected in his orders. Do you think anyone could call him on it? No. But I just want you to be aware of it, that you are much better off trying to mediate agreements and submit those to the court instead of going to trial. And so then after pretrial, if the parties still can't reach an agreement, the courts will set it on for trial. And you're going to have to tell the court how long you think it's going to take. And preparing for trial, obviously, I don't recommend that for anyone on a do-it-yourself divorce. If you're doing that, you should really have the advice of an experienced family law attorney, because the court's going to expect that you prepare witness lists and exhibit lists and be prepared to testify. And if you have witnesses, you need to understand the rules of evidence. And that's where you're better off paying someone who really knows what they're doing. But that is the next step. And if the parties can't agree, and if they've both answered, then that is what the next step is going to be. So, but if the parties have a stipulation, then the next one is default hearings, and that can be brought at any time. Even so, if you get, if the court says, okay, you have to do mediation and you already have an agreement, you just simply file the stipulated judgment and decree with the court, and the court will just sign it, and then they'll take that hearing off the calendar. So it always pays to be prompt in your filings and in getting things done. And then the final time frame I want to talk about is motions for temporary relief. And hardly anyone uses these anymore, but you can get a motion for temporary relief, and it can be done at any time. Hennepin County says it won't listen to motions for temporary relief until after the ICMC. But in most other counties, you can bring it. Although most people don't want to spend the money to bring a motion, I will say there are self-help forms online that give you instructions on how to do that. And the only reason to bring a motion for temporary relief is if there's housing issues, if one party is dissipating marital assets, or if support is needed, spousal support or child support. And those are the three basic reasons to bring a motion for temporary relief. And the only thing I want to say about it is the law recently changed. I don't know when you're hearing this. It changed January 1st of 2021 in that if you're going to be submitting any motions and including any paperwork that includes account numbers, they're called restricted identifiers. And you have to be really careful in looking at those requirements, and those are online. And then the other important point is if either party is receiving public benefits, and if either party is receiving public benefits, and I'm saying, WIC or MNsure or medical assistance or even cash assistance, you have to notify a notice to public authority. And we'll be talking about those at length in the next module. So I just want you to be aware of the court is going to put your matter, once you file it in district court, the initial filing, the summons and the petition and those initial pleadings that I talked about, if you're not also filing your stipulated judgment and decree, you are going to be put under court timeframes. And I just want you to make sure you read the documents and you comply with the dates, because if you don't, again, it could seriously affect your position in your divorce, including the court dismissing your action altogether. And that's the end of this section.